so we have several more grand rounds scheduled for this academic year, so stay tuned for those. But for today, we have 2 speakers, as well as the executive director, April Banerjee, from the People with Disabilities Foundation here in San Francisco. So our 2 speakers, but actually, well, I'll do a reverse presentation. Janet Espey is going to start us off, right? And Janet is an attorney at law who works with this population, but is also on the board of the foundation and got her JD at Hastings. And then with her is her colleague, Stephen Bruce, who has many years also in this area, including the Office of Civil Rights at the U.S. Department of Education and Health and Human Services, and also senior attorney, staff attorney at the Social Security Administration. So between both of them, a lot of experience in this area, and Stephen got his JD at the University of San Francisco, or mix them up. But I will leave it at that and turn the floor over to them. And I think they have handouts, so we're not going to really use a PowerPoint so much today and refer to the handouts, but I'll leave it to their capable hands to walk us through that. Thank you.
Thank you. Hi, so I'm Janet Espey, and can you all hear me okay?
Yes.
Right here. Oh, okay, very good. So to start things off, just before what we're going to do is I'm going to talk about the topics in the first part of the outline. We're going to generally talk about capacity and how the definitions change depending on the circumstances. Then I'm going to be talking about capacity from a legal perspective and looking at various legal contexts such as estate planning, looking at who the people might be that you encounter that are helping patients that you might have, who the fiduciaries are, whether they're court-appointed or appointed in documents. And then talking about planning for changes in capacity and what sort of capacity criteria there is for either people signing their own documents or having a court impose a conservatorship, and then documents that the medical professionals might be asked for. And whether or not you want to fill them out or provide them, that's a part of it too. So just starting off, the legal definition of capacity, as I said, really depends on what sort of a circumstance that you're in. And I think for my purposes, it's going to make sense to talk about the requirements for finding that someone either has or lacks capacity as I talk about each area. And Stephen, did you have a comment or two about the definition as it relates to disability?
I just want to say that the definition of disability is really not the same in Social Security versus workers' compensation versus Americans with Disabilities Act or Section 504. They're all different, and I'll be focused on Social Security disability, which is a combination of medical vocational, and we only have you're disabled or you're not, and it's long-term, whereas other definitions are not dependent on vocational, and it could be like state disability, short-term, and partial disability, as in workers' comp, partial or the full, and then long-term or short-term. So an ADA, or the Americans with Disabilities Act, really is interference with a significant life activity, such as walking, talking, thinking, as a definition of disability. If you want to have, or you have protections under the Americans with Disabilities Act. So just keep in mind the word disability, it depends upon under which statute as to what the definition is. Thanks.
Thank you. Oh, okay, so starting out, the different types of caretakers or fiduciaries that are empowered either under legal documents or by the court. There's 4 different kinds. First of all, you have informal ones that are actually not necessarily empowered by documents or otherwise. That might be family members or friends that are signing checks for somebody or, bringing them to appointments and doing things like that. That will work as long as the person agrees, and goes along with it. Then there's people that are appointed in estate planning documents, court-appointed individuals, and the rep payee. So for people appointed in estate planning documents, each estate planning document has a different fiduciary role. So if you're talking to someone that says, oh, I'm the trustee of this person's trust, special needs trust, regular trust, I'm successor trustee, that person only has authority over assets in the trust. And they can manage those assets and, do things like pay for, the beneficiary of the trust. An agent under a power of attorney is somebody who is authorized to act on the person's behalf for non-trust assets. So if someone doesn't have a trust, or often if they have a trust, but they have assets such as, Social Security, dealing with, if there's a lawsuit related, maybe they're injured and they've lost capacity that way, they might have somebody stepping into their shoes to act in their stead. You can have an agent or attorney, in fact, for healthcare decisions under usually an advanced healthcare directive or similar document. And then there's an executor under a will. Sometimes people get the terms mixed up, but when someone's an executor, it means that the person's passed away and the authority begins with death and goes forward. Authority under a health directive and under a power of attorney is only during lifetime, and it's going to end at death. The trust is unique in that the authority transitions through death, so the same person stays in there, and that's why people like it for probate avoidance, if you hear about that. So, okay, so those are people's estate planning documents, and then there are different types of conservators depending on the court proceeding. So in California, there's 3 types of conservatorships. One is the general probate conservatorship. Then there's an LPS conservatorship and a limited conservatorship. So the general probate conservatorship can either be over the person or over somebody's estate. And these are very common when people become elderly and need to have someone step in to manage their affairs. They might come up when somebody has estate planning documents, and because their changes in their capacity might involve some fear or paranoia, they might be fighting someone stepping in under their documents to where you need to have the court step in and impose a conservatorship. So the court supervises the care of the conservatee and has different criteria for whether it's of the person or of the estate. So a conservatorship of the person is imposed when the person cannot properly provide for his or her personal needs for physical health, medical care, food, clothing, and shelter. And usually you have to, explain to the court what's going on, and kind of build a case for why they should impose the conservator of the person. The conservator of the person decides where the conservatee lives. They're able to determine who their care providers are, and also within some limitations, they can pick who the person sees, and they can control access to them. Like I said, it's all court supervised, and the standard is to give the conservatee the least restrictive environment. So a conservator of the estate is appointed for someone who is substantially unable to manage his or her financial resources, or to unable to resist fraud or undue influence. So you can have people that might be presenting as very capable, but they might need a conservator of their finances. I think of Britney Spears, who's really doing well. her situation really improved when they imposed a conservatorship for her, and she's, obviously able to work and has, it has a great deal of what we would call capacity, even though, she wasn't able to resist the fraud or undue influence. So the LPS conservatorship is for mentally ill adults, and it's temporary. And it usually it's imposed when someone needs mental health treatment and they're not willing to accept it voluntarily. And for a court to determine that somebody is incapacitated for purposes of this, they have to find beyond a reasonable doubt that the person is gravely disabled. So it's kind of a different criteria than for, obviously for the probate conservatorship. It may be of the person or estate or both, and the LPS conservator may arrange for placement in a locked facility and may agree to use of psychotropic drugs, although the conservatee may be able to, they may have rights not to take them. That's complicated topics that we won't get into. Then the limited conservatorship, and I gave you the probate code sections for it. It's under probate code section 1828.5. This is for people who have developmental disabilities, and usually there's someone who's already in the system with a regional center, and they, times I've seen these set up is when, maybe a situation changes where there's additional money available to the person, and, they need an extra, the person, they need someone beyond like a rep payee or someone who's already in place to be managing things for them and making decisions related to where they live and things like that. So the judge in this situation reviews what the proposed conservatee has the ability to do him or herself, and they tailor the conservatorship to fit that. And the idea is to provide as much freedom as possible, for people that have developmental disabilities. If the criteria for this, the court looks at if the proposed conservatee is able to care for him or herself or for their property in the way a reasonably prudent person would. So that's very general. So if they find that no, that's not the case, then they can impose it. The fourth type of person that might, have authority would be a representative payee. And Stephen's going to talk about that. That's really specific to the agency. Yes.
For this audience, I just want to underline one of the points that you made.
Yeah.
So someone is in an emergency room. I've got
Yeah.
these calls, and the resident says they're on a conservatorship. Do
Yes.
I need to 5150 then? So based on what you just said, the answer is it depends what kind of conservatorship. So if it's a probate conservatorship, the answer is yes. If
Yes.
it's an LPS conservatorship, the answer is no. It's confusing, and in California, it's called, the probate conservatorship is called conservatorship. In other states, it's
Yes.
called guardianship.
That's
so
right.
that's a little easier than a guardianship or a conservatorship. So just
Excellent. Thank you. Excellent clarification. Yes.
Question on the general probate concern. So
Yes.
are those two of the person and of the estate like mutually exclusive, or can they
They can overlap, and what you do when you're filing for the petition is you make allegations about each one, separately, and then the court will decide, whether both are required or whether just one or the other is more appropriate.
So you might have some ability to oversee the finances if you're doing a person, a conservatorship.
Yes.
A person just because you don't need to also get the estate one.
Yes, and what's interesting with that is, because of the, oh my goodness, I have so many topics to go. Okay, because of the findings for the conservatorship of the estate being unable to resist fraud or undue influence, That may not have much to do with cognitive functioning. It might just be the person, if family members notice that they're making a lot of gifts to caregivers, or, they're not, they've got telephone solicitors calling them all the time. The court might impose it just based on that, and they're not looking at other criteria. So you can have it just for one and not the other.
I know you're in a hurry. I have one more question.
Yes.
One of the things we often run into is that we want the family to have conservatorship of person or finances.
Yes.
But it's very expensive to hire a lawyer
Yeah.
to do that.
Yeah.
And the public guardian's office won't take those cases if there's a family member there, even if they can't afford it. Is there a cheaper way to do it?
Ideally, with estate planning, particularly if someone's aging and you can, anticipate this. That's a big goal of planning, is planning for incapacity ahead of time. And that's the least expensive way to do it. There's also shifting into, if someone has capacity to plan, there's different criteria for capacity depending on the type of document. And so you may have a gray area where an attorney might be comfortable setting up a power of attorney or other document to allow someone to help. And if the person's agreeable and you don't have difficult family members, sometimes you can kind of, it'll work if no one's objecting to it, because, who knows that that's really the problem. Someone might be willing to sign it and an attorney might be willing to set it up. If it can become difficult depending on the type of document and the sorts of powers someone is giving, whether an attorney's willing to do a document or not. For example, a client that wants to leave property in a will or in a trust to a beneficiary, their capacity can be very low. They can be hallucinating. All they need to know is who the objects of their bounty are and that they have property at all. If they can say, I want my mother to get everything, then you can draw, ethically, I prepare a will for somebody and have them sign it. Having that same person sign a power of attorney, naming someone to manage their affairs, there's a whole other criteria for capacity in the probate code, and it's in the notes I gave you, under section 811. You have to show, in order for a person to have capacity to sign a document, such as a power of attorney, a deed transferring a house, things like that, they have to show that they don't have a deficit. Either they have no deficit in any of the areas listed there, or if there is one or more deficit, that there's no correlation between the deficit and their ability to sign the document. And the areas they list there have to do with alertness and attention, information processing, thought processes, and ability to modulate mood and affect. So if somebody, and then it is a problem that the conservatorships are so expensive. Sometimes to assist, courts are willing to waive the court fees. If you've got someone that just doesn't have the financial wherewithal to pay them, but you are stuck, either trying to find an attorney that will do it pro bono or, having to pay some attorney fees for the person. So let's see. Documents that you might be asked to provide as medical professionals. A lot of estate planning attorneys now include provisions in their documents that will trigger the documents going into effect. So, for example, in a trust, it might say that when the person whose trust it is deemed to no longer be able to resist fraud or undue influence or to manage their affairs, and 2 licensed physicians are willing to write something, stating that, then the successor trustee will be allowed to act. And that will work. The successor trustee can take that document with the 2 letters to a bank and get put on an account or to handle things. So powers of attorney might have that built in, where the doctor, is required to find that the person lacks capacity. Also, more and more, as people get into contesting documents, I go to a lot of attorney seminars and we talk a lot about, well, let's, have the person assessed ahead of time and show that they have capacity. Or if they have one of the problems in that probate code 811, ideally someone would say, well, that's not going to interfere with their ability to sign the document. So you might have people asking you, to say, oh, my mother is able, mom is able to sign, because even though she's forgetful, it's not going to impact her ability, to name someone to manage things for her, things like that. So, and let's see what else. I think the other thing that you might be asked to do are completion of court forms, related to the different types of conservatorship. And those are very specific to the findings required for each one. And so they're usually forms that are pre-printed with boxes, for the professional to review and fill out. So does anyone have any questions before we shift gears and go to Social Security? Okay.
I'm Stephen Bruce, who's the legal director at People with Disabilities Foundation. First of all, I'm going to sit on this stool because I have a leg injury. Today I'm going to talk about Social Security. Can you hear me okay without the microphone?
Yeah. Could you bring it down a little?
Oh, yeah.
That's
Is this better?
much better, thank you.
Thanks. So there are two Social Security programs. The poverty program, which is SSI, which has income and resource eligibility criteria. And SSDI is the regular Social Security where people have insured status if they've been working generally 20 out of the last 40 quarters, which is about 5 out of the last 10 years. And people can be concurrently on both. I'm going to quickly go over the process because it's actually extremely complicated. You apply for benefits, and then if you get denied, you ask for reconsideration. And it really goes back to the state agency. Each of the 50 states are contracted to make that medical determination of disability. And then if you're denied, you ask for a hearing before a judge, an ALJ. And after that, there's an administrative appeal. They're all sent to Falls Church, Virginia. And then you wait a year to 2, and then you sue Social Security in federal court, which is the real appeal. The whole thing could take 5 years. Putting that process aside, I mean, the point is it's very lengthy, it's elaborate, and it's complicated for people who are too disabled to work. Now, Social Security, as I mentioned earlier, is a combination of medical vocational. The definition of disability is considering an individual's age, education, and past relevant work experience, which is defined as the past 15 years before onset of disability, and taking into account their residual functional capacity given their impairments. Are there jobs that exist in significant numbers in the United States economy or regional economy that they are capable of performing? That is the legal standard. We do ask that psychiatrists please don't write a letter saying my patient is disabled. There are 2 reasons why that cannot ever be used. It's too conclusionary, and it's not up to the doctor. It's not like workers' compensation. The judge will decide. And the diagnosis is not so important. It's their functional limitations that are important. And a doctor cannot give vocational testimony or evidence. A vocational expert does that. And likewise, the vocational expert cannot give a medical opinion either. So we like to look at the medical side first. get a residual functional capacity, the maximum they can do notwithstanding their functional limitations, and then turn to the vocational side and see if jobs are available in the United States. They don't really, actually they just have to exist. They don't really have to be available. Exist in significant numbers in the United States. So it's a very stringent standard for people. Now on the outline, I am talking a little bit about documents, and there's only one enclosure, which is a document that I send to psychiatrists. And it's the medical assessment of ability to do work-related activities, mental. So we have definitions on the first page, and they're like Social Security's definitions where they use none, mild, moderate, marked, and extreme. These are poor, fair, good, but they're defined, and they're very similar. And then we really want to, for example, for most mental disabilities, we want to see if someone can keep up pace, persistence, and concentration to perform tasks in a timely manner, under supervision and with coworkers, on a sustained basis, which means day after day, week after week, month after month in full-time work. And that CPP, concentration, pace, and persistence, and the word sustained especially applies to psychiatric disabilities as opposed to physical disabilities. And we have various categories on this 3-page form. Actually, it's called 4 pages, but it's just the signature pages, page 4. So you see making occupational adjustments and performance adjustments and personal social adjustments and other work activities. And we want to know if you believe your patient, my client, can do this with one 30-minute break and 2 10-minute breaks in each 8-hour workday. And the answer may be yes or no, and what we need to support that is not a diagnosis, not just bipolar 2 or psychosis, NLS, or schizophrenia, or personality disorder, but we really need, the evidence that we look at is the chart itself, including handwritten or typed notes. It is, so a diagnosis in and of itself is not that useful. I'm not going to say it's not useful at all. I always ask doctors to, please provide a narrative indicating your patient's diagnoses and all resulting functional limitations. But it's the second part that we need. So in the end, we come up with the medical RFC, resulting functional limitations. And then we turn, let's say it's a hearing. We may have a doctor testify about summarizing the psych record, clinical record, and we have a vocational expert testify. And we ask the vocational expert, given these limitations, can't deal with the public or can't focus on more than repetitive 1- and 2-step tasks like bench work, are there jobs that exist? And often the answer will be yes, and the reason is, in Social Security, it's minimum wage, unskilled, and I'm going to say sedentary, that is physical, but still type of job, that if they're under 50, they have to prove they cannot do that to come out disabled. Cannot do on a sustained basis, unskilled, minimum wage type work. If they cannot deal with the public, for example, there are plenty of jobs that exist in the United States that does not require dealing with the public. So that can make a difference more for older people. The older someone is, the less difference in industry, the trade, or tools that's required. And the younger someone is, you're really talking about that unskilled, sitting type work. And vocationally, it goes from if someone is off task, let's say more than 10% of the time each day, the lower the skill level, the more difference that makes. So for example, if the claimant, which would be your patient, my client, is going to miss more than one unexcused absence per month, there are jobs that they can do, unless they're semi-skilled or skilled in their work, and the higher the skill level, the more unexcused absences that'll be tolerated by the employer. And these statistics really come through the Department of Labor, Bureau of Labor Statistics. I'm not going to go into it here, but they have a lot of books. We still rely on the Dictionary of Occupational Titles, last published in 1991. We have to use them as updated by a vocational expert's testimony, because that's the way Social Security regulations, that's what they require. So there's been some talk from Janet Espey about conservatorships and rent payees and fiduciaries. In Social Security, there is a representative payee regulation, which is solely based on one's ability to manage funds. It is a medical determination. And if they're required to have one, it can be changed by a form, a Social Security form, that is, not any other form like from a state probate judge or something. And basically, it's going to need medical evidence about your patient's ability to manage funds. And what they're concerned about is the benefit check. And so every month, whether it's direct deposit or not, a check is coming. And if they can't manage it, it's going to be a representative payee. Of course, a lot of people want to get rid of the payees. They want the money so they can cash it and buy things. And we do help people get off the status of requiring a payee, but we really need their doctor to make the determination of capacity to manage funds. It's not enough to have lay witnesses or just the lawyer petitioning to have that done. And often we say, please keep your rep payee until they have given you the retroactive and you get your checks going. Don't try to change it. You can try to get rid of your payee, but wait a few months, because it'll hold up the whole process for someone who's spent years applying and has finally gotten on. So there are a lot of regulations, none of which am I going to go into right now, about payee liability. In the last few years, Social Security has come up with all kinds of standards and liability and reporting, because it's the payee who has to report any changes, for example, in work activity. They are responsible. And if there's an overpayment, which happens all the time, and people get these notices of overpayment on either program, SSI or SSDI, and for both programs, you're going to get double notices of overpayments. It's the rep payee who needs to report changes in income, whether it's earned or unearned, if they're on SSI, because remember I said there's both resource and income eligibility criteria. So, and the work incentive programs are not the same for SSI disability or SSDI disability. It can be very overwhelming for this population to get all these notices because their computer has picked up they got money from somewhere, especially if it's from working. And they're facing what's called the CDR, Continuing Disability Review, and which means the agency wants to cease them. And once they get a notice of cessation, within 2 weeks they'll get a computer-generated notice of overpayment, And they range all over the place, certainly up to $100,000 for someone who's just living month to month. And the whole process is extremely daunting. And every year in the past, I guess, 10 to 15 years, they've been increasing the quotas. In every field office, there's about 1,500 in the United States to do work reviews. The only other kind of review is a medical CDR, in which the administration has the burden of proving medical improvement. They're cutting people off right and left. It's maybe politically motivated, but that's the way it is. Social Security is a political, it's controlled by Congress, and it depends who's on the Ways and Means Social Security Subcommittee, who pressures the agency to do more reviews, cessation reviews, that is. So, SSI, I keep saying income and resource criteria, it's $2,000 per person, or if two people are married, gender doesn't matter, it's $3,000. Gender meaning LGBT community, they're now, since the U.S. Supreme Court case, treated the same, $2,000 per month or $3,000 for SSI, and income is dollar for dollar. If you give an SSI beneficiary $100, their check will be reduced $100, even if it's to buy food. If you want to give someone food, just give them the food. Don't give them $100. So there's all kinds of detail, but it's a complex system, and I just want to hit on the most recurring, frequent issues that may come up in a practitioner's, let's say, a psychiatrist practice with what to do. They have disabled adult children, DAC, where they can be paid on the account of another. It's usually a parent, but the parent has to be dead or disabled or retired, and the adult child has to be disabled on or before age 22 and continuously since. Now, there's all these criteria under a lot of categories. There's widowers, there's disabled divorced spouses, there's maybe 20 different categories, but each set of regulations are different. They're really not the same. Maybe they needed to get half of their support contributed to the account holder before his or her death on some of them. Maybe it's a grandparent's applying because their son died, and maybe the decedent's son is applying for child benefits. So, again, this seminar is too short except for you to realize that each category has different requirements for eligibility. And that's the important thing to take out of it. Now, post-entitlement, post-eligibility, yes.
I have a quick question about a patient that I saw who had an end-of-life illness and had been disabled as a child and married in her mid-20s and then divorced 5 years later, had SSI, and tells me that she was never able to get back on after her divorce. Is that what you mean about all these strange specific regulations?
Well, on SSI, if someone was married and living in the same household, they do something called deeming. The spouse's income and resources are deemed to the other, but we don't tell people to get divorced because they don't have to. They just need not to live in the same household.
But they did divorce, so I'm just wondering why she wasn't ever able to reapply, and she claims has been denied multiple times.
Well, if she's been denied multiple times, I guess she has been reapplying. Maybe they didn't find she was continued to be medically disabled. It's hard to tell. But with SSI, if you go off the program, you can be reinstated without reapplying so long as it isn't over 365 days. And if it is, even for a non-medical reason, like just being in prison or something, but otherwise you need to reapply and prove you're disabled again. That's the 1 year rule. But no, I can't answer your question about, I mean, there are rules where a disabled adult child, someone who's been disabled since childhood and continues under SSDI, the insured program, they cannot get married. And if they really want to get divorced, they should really see me or another Social Security lawyer, because the advice is get an annulment, because once you're married, you're not going to qualify for disabled adult children's, because those are the rules under disabled adult children's regulation section. So that's really important to, even before you talk about someone got divorced, there shouldn't have been a divorce versus an annulment. I know it's easy for me to say in hindsight, but it's just the way the Social Security Act and its regulations work. Someone, namely Congress, made it extremely complicated. Post-entitlement or eligibility, with SSI every year, there's supposed to be an annual redetermination that they're eligible. And they have to go into the field office and they have to fill out forms, including a work activity report. And they have work incentive programs, which I'm only going to briefly mention because they're complicated and they're not the same as the work incentive programs for SSI. So that you have a 9-month trial work period, you can earn any amount each month, and the months don't have to be consecutive. You can earn $1 million a month, and you're not going to be, it's not going to affect your benefits. After the 9 months, you begin a 36 extended period of eligibility, where if you go over the year's substantial gainful activity amount, this year, 2017, it's $1,170 a year. If you go over that, you're not getting benefit checks that month, but you don't need to reapply. For 36 months, you can go on and off. And then on SSI, it's very different. It's the 2-for-1 rule. At least that's what I call it. For every $2 you earn, you're going to lose $1 from your check. Now that's a really good program, because say your check's $800 and you can make $1,600 plus there's a small pass through of up to $65, and you can go to zero for your check amount. You'll still be Medi-Cal eligible. So there's a lot more room so people could engage in work attempts. And I usually advise people to try to work if they can, because an unsuccessful work attempt won't be counted against them, whereas a successful one will be. And a work attempt, if it lasts for over 6 months, by legal definition, will be successful. It's only 0 to 6 months where it can be characterized as unsuccessful, so long as they had to stop working based on their disability. So I'm just trying to contrast the two sets of programs, and for those poor people who are really on both programs, they're going to get double notices. They're going to be bombarded by notices because the two programs don't have the same work incentive rules. They're really different. Now, they did tell me when we sued them years ago they were going to make them the same. This was in the year 2009. And last week I just saw a notice of a demonstration project. So that's 8 years later that they are having the 2-for-1 demonstration project in parts of the United States under SSDI. It really has taken 8 years for them to even start what they told us 8 years ago. So suffice it to say, there's no change, and even if there is, it's not going to be for years, because it's slow with that. If anyone has any questions, I realize I'm only hitting certain areas, but frankly, in under an hour, it does get maybe more complicated than you want to know. Absent, yes.
I do have one question. Thank you so much. I understand much more about how the whole system works. Our healthcare system, purportedly, according to the New York Times, every third dollar delivers no care, only administration. It's the most expensive administrative healthcare system in the world. This system, if you look at a dollar, how much of it is eaten or consumed by vast administration?
Well, they've measured that on the program of recouping overpayments, which, and you can go through this whole process, reconsideration, the ALJ hearing and all this on an overpayment also, and they determined that for every dollar they spend administering that and recouping overpayments, there's still a net savings. I don't remember exactly how much. In terms of the whole administration, their administrative budget is $1.2 billion a year, which, if you compare that to the $60 billion a month in checks, including retirement that they send out, it's only about 1/60th, because it's a huge budget, the Social Security budget and payouts. So it's over $1 billion to administer it, and, to pay every employee and all that sort of thing. But you have to compare that to the size of the program. $60 billion a month, 60 times 12, which is $720 billion per year. So they do those comparisons. You said healthcare. You weren't really talking about Social Security, but for Medicare, which goes with SSDI or Title II, and Medicaid, also known as Medi-Cal, goes with SSI. And for those concurrently on both, they get both, Medi-Cal and Medicare. There is a 2-year waiting period for Medicare. So if someone's found disabled in November 1st, 2017, they wait 5 months to the date of entitlement, which is going to be, I guess, April 2018, plus 2 years. So it's April 2020 until they get their Medicare. And that's the 2-year or 24-month waiting period for Medicare for those people on Social Security disability. For Medi-Cal, it'll come a month after the month they apply. They do not have to wait 2 years. And they just set the programs up like that. I can't give you a rational basis for why they do that. Yes.
Is the $2,000 a month or $3,000 for all of California or just for San Francisco?
Well, neither. It's for the United States.
So it doesn't matter if you live in Arkansas or if you live in
No.
San Francisco?
No, it doesn't.
It's $2,000.
It doesn't matter. That is correct. I mean, there are some, and of course it's complicated, exemptions, but that's the resource limit. It's $2,000 nationwide. And it always has been. SSI started, I think it was 74, SSDI before that. They've never increased the $2,000. What they did, which in California started this year, is the ABLE accounts, where someone could shelter, I think it went from $14,000 to $15,000 a year in an approved bank account, and it was not countable. Other examples of non-countable sources are in a special needs trust, which my colleague Janet Espey, I think, just mentioned. There's other income sheltering programs like a PASS plan, a plan to achieve self-support, which must be approved by them, meaning Social Security's headquarters in Baltimore. But that way, you can have an account with a realistic vocational goal, and if it's Title II money, and your SSI will go up to the maximum because it's not countable. Some people can use it to get through medical school or a PhD program or law school, or less. It has to be realistic as a standard. So there's no limit on what degree of education and or vocational training might be required. So that's just another example of sheltering income. Those 3 examples, rather. Yes.
So you've been referring to physicians throughout this.
Yes.
Can nurse practitioners also do these evaluations for SSI or SSDI?
can their treating doctors, is that what you're saying?
No, if a patient is being cared for by, say, a psychiatric nurse practitioner?
Oh, nurse practitioner. They have just changed the rule effective 2017. And they, for the first time, included psychiatric nurse practitioners. I mean, as opposed to other kinds. Now, for all these years, I would have said, no, it has to be an MD or or clinical PhD psychologist because of the psychometric testing they do. But no, that's just now changed, effective to applications filed on or after March of this year. It's brand new. Thank you for asking that. A lot of things were just revised. Yes.
Are there other sort of pitfalls to avoid when, as a whatever clinician you are, and you're interacting with your patient and assisting with their process of applying or appealing for a benefit? Is there anything else?
Well, if you're assisting with your patient, it's important to know the evidence they use. I already said it can't be too conclusionary, like my patient can't work. That is thrown in the garbage, basically. You need to go into the factors like concentration, pace, and persistence in doing sustained work activity. You can think of it that way. Or the handout is a form that I mail to the psychiatrist. I'll take a narrative stating, please state your patient's diagnoses and all resulting functional limitations. The judge is required to look at all impairments in combination, whether they're mental and or physical, to see if they can, and then the same standard I've been saying, to do full-time work activity week after week, month after month, etc. With those breaks, lunch and the 2 10-minute breaks. So I think, keep in mind, just don't think sending a letter, it's not going to help. Unless the letter goes into the functional limitations that interfere with someone able to do full-time sustained work activity, as is broken down on the handout, the RFC handout form. There are other ways like listings. The 12.03 is psychosis, 12.04 is affective disorder, 12.05 is intelligence, then the anxiety disorders, but then you have to, that's the highest level of severity, and you really, sometimes I will send those listings to a doctor because you may need over 6 months of this and 2 hospitalizations within so much time, or epilepsy, you need after 90 days of treatment to have so many documented seizures, whether we're talking about the big ones or the little ones, is part of it too. But basically, it's just what I said there, is just keeping that standard in mind, the medical, vocational, and that they will need and subpoena, if necessary, the chart. And they have a right to it, otherwise your client will be denied for not cooperating. And I mean the clinical chart, because that's where the evidence is. We, meaning whether it's the lawyer or the judge, we try to read your handwriting, I mean, if it's handwritten, because that's the evidence. They don't accept conclusionary statements, as opposed to workers' comp, where the doctors actually determine causation and all kinds of things, but not in Social Security. It just doesn't work like that. If there are no other questions, yes.
Can we go back to the conservatorship for just 1 minute? I have been told that if a family's going to go spend $3,000 to $5,000 for the first year of conservatorship, that they're less likely to get it in the absence of a dementia diagnosis, even with mental health. Is there any truth to that? Or is it worth the family's time with just a mental health diagnosis to try to get that conservatorship of person or conservatorship of finance?
Well, sometimes,
Probate, yeah.
Yeah, sometimes families are, if they're very concerned about cost, you can end up in a situation where the family kind of muddles along without going, so even when there is a diagnosis, they might be just going along as best they can and making do and maybe just leaving things be, and having, the parents sign checks, things like that, even though they have the dementia diagnosis. If there's that diagnosis and the person's unable to manage their financial affairs, sometimes the family will go for conservatorship of the estate and not of the person. So you can always do that, and just set it up so that the person can't access the finances. That's often advised, I know sometimes when people get a diagnosis, like an Alzheimer's diagnosis, I've had people tell me a lot of times that they were told to do planning right away, because sometimes, the crisis that might happen might be a financial crisis where the person, starts making decisions about their finances that they wouldn't have otherwise. So that can also be something when someone first gets a diagnosis where you can be in kind of the gray area where maybe the aspects of the diagnosis may not really interfere with their ability to sign a document. If you look at what they're doing, which is maybe naming someone to manage affairs for them. And sometimes people do go sign estate planning documents, rather than going through the court proceeding. So does that answer your question?
I guess a little bit, it was helpful. A lot of the times we're in the middle of a crisis in that we need to take control of somebody's finances and make them live in an assisted living facility is most often times the case. If in the absence of planning in the middle of a crisis, we've been told that it's less likely for a family to get it on mental health alone without Alzheimer's diagnosis. Is that true?
Gosh, not necessarily in my experience. They have some extra powers called dementia powers that might have to do with requiring the person to take certain medications. And that's an added power that you can request when you're filing for the conservatorship. When the court is looking at, ability to resist fraud and undue influence, because that category gives them it gives them a lot of latitude. So if you can, make a case for it, they'll often grant it. When the court's doing a conservatorship, they actually send out, the court personnel that are social workers, they're trained, and they meet with the conservatee, they interview family members, anyone who, sometimes they'll call the bankers or people that do that, and they'll often advise something. I think they're pretty flexible, as far as at least of the estate, maybe of the person, no. Of the estate.
Thank you.
Sure.
Well, we're past our time, but thank you so much.
Thanks.